John Farrell with the Farrell Law Firm. Today we're going to talk about the biggest mistake married homeowners make with estate planning. But first, make sure you subscribe to the channel. We put out new videos almost every day, and make sure you hit the like button because hey, every like helps. John Farrell with the Farrell Law Firm. To tell you a little bit about myself, I'm the author of Estate Planning for the Modern Family, and I was recently voted one of the top 3 lawyers here in Cobb County, Georgia, along with the law firm being voted one of the top 3 law firms here in Cobb County, Georgia. Today, we're going to talk about the biggest mistake married homeowners make with estate planning. There can be several mistakes that married homeowners make with estate planning, but today, we're just focusing on the biggest mistake. I'll put a video out later about the other types of mistakes married homeowners make. The biggest mistake married homeowners make in Georgia is incorrectly assuming the surviving spouse will get the marital home once the first spouse passes away. More often than not, most of the surviving spouses I've spoken with are confused in the way their property is titled. They assume the property is titled jointly and that the property will pass to the surviving spouse. But in Georgia, it depends on how the property is titled. Generally, there are different types of ownership, but the 2 that should concern most married homeowners are called joint tenancy in common and joint tenancy with rights of survivorship. Under a joint tenancy in common ownership, once the first spouse dies, their interest in the marital home must be probated. Under a joint tenancy with rights of survivorship ownership, once the first spouse dies, their interest passes to the surviving spouse. Most couples assume their property is held under a rights of survivorship ownership. Unfortunately, that is not the default in Georgia. The default is joint tenancy in common. So if the deed doesn't state that it is with rights of survivorship, then it may need to be probated once the first spouse dies. Take the time to find and review the deed to your home. Typically, a copy is given to the new owner at the closing. You'll want to make sure if you are married and you're expecting the property to pass to your spouse upon your passing, that it is held with rights of survivorship. Otherwise, you may be making the biggest mistake married homeowners make with estate planning. That's really all we have to talk about today. If you've watched our videos for any amount of time, then you know what we do is we help people plan their estates. To do that, we've created a book called Estate Planning for the Modern Family. You're going to want to get a copy of this book, so I'm putting a link in the description below so you can order it online. It will tell you all about wills, trusts, powers of attorney, and the probate process. It also comes with a bonus. The bonus is if you have trouble sleeping at night, you can read it and it will get you right to sleep. So make sure you read it in the morning. If you want to learn a little bit more about the firm or maybe schedule a free consultation for yourself, give us a call at 678-809-4922. That's 678-809-4922. I'm also putting a link in the description below so you can reach out to us to schedule that free consultation. All right, that's all we have for today. Make sure you subscribe to the channel because we put out new videos almost every day, and make sure you hit the like button because, hey, every like helps.